Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And if you're interested in the FDCPA, the Fair Debt Collection Practices Act, and what courts actually write in opinions, then I think you'll like this video. We're going to mainly focus on the idea of a bona fide error. That's a defense that debt collectors have to say, yeah, I violated the law, but don't hold me liable because I have this bona fide error. And specifically, we're going to look at, can the debt collector say, here's my get out of jail free card. I told the creditor who sent me the account, you only give me accurate information. That's it. See, I'm good. I'm golden. I'm totally out of the woods here. I can't be sued for the FDCPA. The district court, the trial judge, bought that argument. The appellate court, the Ninth Circuit Court of Appeals, and this is a November 5th, 2020 decision, said, no way, you lose. Okay. So at least the summary judgment is denied and go back and we have to try this case. So let's look and see what we've got here. It says it's for publication. It's a little bit tortured history. First it came out not for publication, means it's not quite as important. Then they changed their mind. So it just means the court feels like this is an important decision. And the Ninth Circuit is basically the West Coast. So let's look and see what we're talking about here. They tell us up front what the issue is. Whether a debt collector may invoke the bona fide error defense to avoid liability for violating the FDCPA. Well, how? By contractually obligating creditor clients to provide only accurate information regarding delinquent accounts. Now, this will remind you of the Kotler case from the 11th Circuit that we did a video on a few days ago. And the debt collector, this MBF, says, hey, we required the creditor, which is actually a medical facility, to provide accurate information. We're good. And you can see here the district court granted summary judgment, and they say we reverse. They say, look, all you really did is you just tried to outsource your obligations under the law to somebody else. That's not good enough. So they say, we conclude the bona fide error defense does not allow debt collectors to avoid liability by contractually obligating creditor clients to provide accurate information, nor by requesting that those clients provide notice of any errors without waiting to receive a response. So that second part, let me explain that. What this company would do is they get an account and they basically put it on a sheet and it says, here's the name, the number, the amount owed, interest, all that stuff. They send it to the medical facility and say, let us know if there are any problems. The issue is they claim they sent that and then they immediately went after the consumer. They didn't even wait to get a response back. So the facts are not in dispute. 2014, the debt collector and this Tahoe Fracture Clinic agreed that the past due amounts would come and they would only be legitimate enforceable obligations, accurate data. And the collector says we follow standard practice. We generate an automatic response listing the name, number, amount due, date of last payment. And then we tell our clients, notify us, the collector, if there are any errors. Okay. And so they say they sent a letter to the Tahoe Clinic requesting verify the amount, and they didn't get a response. And the very next day, they start collecting. Okay. They admit that they received an incorrect payment history. And so they started calculating interest in February rather than August. The difference is, so we owed the debt in February, but then we made some payments all the way to August. And that should have been the start date of interest. But this debt collector got bad information. So they started collecting interest from back here in February. So it makes it the wrong amount. Because they charged too much interest to attempted to collect more than was owed, it's undisputed they violated the FDCPA. So remember our recent video about strict liability. If you, as a collector, collect more than is owed, you violate the law. Okay? It's not, well, I didn't have any evil intent. No, I mean, all that comes up in this bona fide error defense that we're going to look at. So the court said, you know what? You did violate the law. This is the district court, the trial judge. You improperly calculated the interest due, but you qualify for this bona fide error, so I'm throwing the case out. That's what the trial judge said. granted summary judgment, just summarily entered judgment in favor of the collector. So the consumer says, wait a minute, you don't qualify for this defense because you did not have adequate procedures in place to prevent errors of the type that occurred here. Now the collector says, wait. We reasonably relied on the medical clinic's promise to provide accurate information, and we notified the clinic of what we were about to do and said, tell us if there's anything wrong. So let's talk about the FDCPA. The FDCPA prohibits debt collectors from collecting any amount, including interest, fee, charge, expense, whatever, unless such amount is expressly authorized by the agreement creating the debt, that would be the contract, or permitted by law. Debt collectors are strictly liable for FDCPA violations. And if you violate the FDCPA, it's actual damages. Now remember, we talked about in other videos, that can be economic damages. It could also be emotional distress damages, attorney's fees and costs, and additional damages not to exceed $1,000 per violation, which almost every court interprets this as $1,000 per lawsuit. Those are called statutory damages. So it's broadly remedial, which means it should be liberally construed in favor of consumers. So what's this bona fide error stuff? Well, that's what's called an affirmative defense. That means they bear the burden of proving this. Okay, the consumer doesn't have to disprove it. The debt collector has to prove that their conduct was not intentional, resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid any such error. The burden is on the debt collector to prove this defense by preponderance of the evidence. That just means if you put the evidence and the scales adjusted, it just tips a little bit in favor of the debt collector. So here the court breaks it out into three sections. Unintentional violation. Number 2, bona fide error. Number 3, maintain procedures reasonably adapted to avoid the violation. No real argument about the first two. It's that third one about reasonable procedures or maintain procedures reasonably adapted to avoid the violation. So now the court's going to say, well, let's look and see what we said before. This is back in 2008. A debt collector is not entitled under the FDCPA to sit back and wait until a creditor makes a mistake and then institute procedures to prevent a reoccurrence. That makes sense. Instead, the debt collector has an affirmative obligation, in other words, they have to do this, to maintain procedures designed to avoid discoverable errors, including, but not limited to, errors in calculation and itemization. And so if you want this bona fide error, you must explain the manner in which your procedures were adapted to avoid the error. And it does not shield debt collectors who unreasonably rely on creditors' representations. Now, this is one reason why it's so important to look at court decisions, is because you can see here, they're going back 2008, 2006, saying, well, what have we said before? Let's look and see what the law is. So we previously rejected the contention that unquestioned reliance on a creditor's information can suffice as a bona fide defense. And they said, we held debt collectors' reliance on the creditor's history of providing accurate information. That doesn't satisfy. So you can't say as a collector, well, they've always sent me good information, so I can rely on it, at least until I get bad information. Well, no, that doesn't help the person that you end up collecting an amount that's not owed. And then they reference the Seventh Circuit in Jenkins versus Heinz. This is back, 23, 24 years ago. Several elaborate procedures that enabled the collector to successfully invoke the bona fide error defense. So this is back in 97. They had a requirement that the creditor verify under oath that each charge was accurate. Number 2, publication of an in-house fair debt compliance manual updated and supplied to the employees, training seminars, an 8-step highly detailed pre-litigation review process to ensure accuracy. There are a lot of steps there, and that was enough in that particular case. And then they say, well, look, the U.S. Supreme Court in 2010 addressed this, and there the court said a legal error in interpreting the FDCPA does not qualify for the bona fide error defense. You can't go, well, it was a reasonable interpretation of the law. No, the law is what the law is. This is strict liability. If this is the law and you go out here or here or here or here, you violated the law. And the court contrasted legal errors that do not qualify for the defense with reasonably adapted routine procedures that might. So here's the Supreme Court saying, the dictionary defines procedures as a series of steps followed in a regular, orderly, definite way. So it's more naturally read to apply to processes that have mechanical or other such regular, orderly steps. So we're talking about more just like, you're sending out 1,000 letters. What's your process to make sure that this letter going to Joe doesn't end up in the envelope going to Jill? It's that type of stuff. It's not, well, I made a mistake on what the statute of limitations is, or I made a mistake on thinking we could sue in this county when really the FDCPA required us to sue the consumer in that county. So going on with the Supreme Court case, broad statutory requirement to avoid any bona fide error indicates the relevant procedures are one that help avoid errors like clerical or factual mistakes. So now we're getting to the 11th Circuit. That's where I practice. So 11th Circuit covers Alabama, Georgia, Florida. So the 11th Circuit followed this lead when it denied debt collector's claim nearly identical to the collector in this case, that an engagement contract obligating the creditor to present only accurate information qualified. 11th Circuit said no. Nice try, but no. And that was 10 years ago in 2011. So also referencing a 5th Circuit case, which is 5th Circuit is Texas, Louisiana, Mississippi. That may be the only states. While a clerical error is one that is easy to commit, it's also a type of error that can easily be detected by implementation of an inexpensive screening procedure. And so now the 8th Circuit has said, look, this is a fact-intensive inquiry. Okay, I mean, you really have to dig into the details. And they say, we agree. But we also recognize that the procedures our sister circuits have approved for catching errors in the data are significantly more likely to catch errors than a form contract requiring customers provide only accurate information. And they say, look, the collector's contract with that Tahoe, fracture clinic, is similar to the contract the 11th Circuit found insufficient in the Owen case. And they say, well, look, the trial judge relied on this case called McCullough. But they say this is distinguishable, which means it looks similar, but when you sort of put it together, you realize, no, these things are not similar at all. And so McCullough denied a law firm's attempt to invoke bona fide error because they unreasonably relied on a file transmitted by another debt collector. And they failed to recognize the relevant collection service agreement actually disclaimed the accuracy. So I want you to think about that. Sort of a side note, when we're dealing with LVNV, Midland, Portfolio, these debt buyers, and if their contract, their purchase agreement says, hey, we disclaim any accuracy, then can they really rely on that for this bona fide error defense? And unrelated, but can they rely on that when they're trying to introduce evidence if the very contract itself says, don't trust it, it's no good? So just something to think about. So then they reference this Turner case. That's what the district court relied on. And where there's an agreement, creditor would only provide reliable information. There is evidence of reasonable reliance. And in the Turner case said, well, we're going to send this back to the trial judge to look at it. And they said it might be enough. So that's what's called dicta, where that's not required. It's just kind of the court going, I think maybe that would be enough, but it's not binding on anybody. But the trial court in the Turner case, when it went back down to Turner, said the reliance on its clients to provide accurate information did not in any way compare to types of procedures found to qualify bona fide error defense. So here's the last argument of the debt collector. They say, well, look, we send our creditor that request seeking verification. They say this is closer to the mark, but still falls short because it's uncontested. You did not wait for a response. In other words, you send it. I mean, it's sort of like saying, I just want to make sure that, it's okay to start the car. And before the person answers, you go ahead and start it. Well, maybe like you're at an oil change place and somebody's working under there. Like if you're going to ask if it's okay, you've got to wait for the response. Okay? Because they do not argue, it routinely waits for the clients to respond It fails to show that this is genuinely calculated to catch errors. And plus, there's a big question about, did they really do that, or are they just making this up? And so they reverse the order granting summary judgment, remand to the district court. So again, very good case. This bona fide error defense, what I find is the lawyers that defend debt collectors that know what they're doing very rarely bring this up. It's more the lawyers that don't know what they're doing, frankly, kind of amateur hour, where these lawyers, maybe they've only defended one case before, and they go, oh, bona fide error. And we just kind of like look around going, oh my goodness, this is going to be painful, because they don't understand what it is. They just think if they can prove this wasn't intentional, they win. No, it's a lot more than that. So thanks for watching this video. Hope you found it helpful, and I will talk to you later. Okay, have a good one. Bye-bye.